right, good morning. This is the Colorado Energy and Carbon Management Commission. It is Thursday, August 31st, and we will take the roll to start.
Yes,
Hearings
Mr. Chair.
Manager Amaro.
Commissioner Ackerman?
Here.
Commissioner Cross?
Present.
Commissioner McGowan?
Here.
Commissioner Mesner?
Here.
Commissioner Oath? Commissioner Ray? Commissioner Robbins?
Here.
Mr. Chair, you have 5 out of 7 commissioners present today.
Very good. Good to see everybody again. Look forward to our agenda. We have one matter on the docket. It is docket 221100286. It involves a financial assurance plan. The applicant is Evergreen Natural Resources. Let's go ahead and elevate Mr. Jim Martin, the attorney for the applicant.
Good morning, Chair Robbins. Oh God, just a second.
The host would like to
We're going to give Mr. Martin an opportunity to undo the reciprocation.
Can you hear me, Chair Robbins?
I can, and I can hear only one of you, so that's good.
Samara.
Okay. So Mr. Martin, I've called to play our docket 221100286, the Evergreen Natural Resources Financial Assurance Plan. I believe my order of play this morning is that I'm going to call upon Director Murphy to see if staff has any additional information. I would then call upon you to see if you've got any final closing remarks, and then we're going to move into deliberation. Does that procedure sound appropriate to you, Mr. Martin?
We do have some closing remarks, Chair Robbins. If staff's going to provide evidence this morning, then we have questions for staff.
Yeah, that's fair and fine. So let me call upon Director Murphy to begin with regard to anything from staff.
Thank you, Chair. Thank you, Commissioners. Hopefully everybody can hear me okay. Okay, good. I have my green bar that I'm talking now, thank goodness. Thanks for the opportunity. I think that the commissioners have identified a number of the questions that staff has also wrestled with, but fundamentally staff's analysis is contained within its director's recommendation, and we don't have much more we don't have anything to add in addition to that. So
okay, and that's fair. Mr. Martin, given that staff really hasn't added anything else, I don't know that there's really much of an opportunity for cross-examination. Would you agree?
I agree, Chair Robbins.
Very good. Then we would recognize you and your group for any final closing remarks before we move into final deliberations.
So, Chair Robbins, the caffeine hasn't fully kicked in yet this morning. Could you remind me, are you going straight from our closing comments to deliberation?
Right. I'd give you an opportunity for closing, and then we would move to deliberation.
Okay. Thank you, Chair Robbins. With enough coffee, I'll actually be able to catch up. So, closing remarks for Evergreen. I want to say that we heard the criticisms of our calculation of demonstrated costs that came across loud and clear. We heard Commissioner McGowan's concern about the absence of as I think she's described it, a retirement plan, asset retirement plan that is. We appreciate that at least some commissioners agree that Evergreen is a candidate for an option 5 plan. We also appreciate that you recognize the company's financial capability, its financial viability. So we have a proposal to make to the commission as you begin deliberations. One is that we would propose calculating reclamation costs, including all costs. That would be $58,000 per site rather than $31,000. Happy to explain that if you like more information. That would increase the financial assurance, the total amount to roughly $9.6 million, that is. Evergreen proposes that it would post a bond for $7.558 million, which rounded off is the amount of financial assurance they were proposing in their proposal to the commission, then would also commit to an obligation of an additional $2.1 million to be invested in a sinking fund or a trust fund, details to be worked out with staff. Since we just came up with this last night, that would be paid in over the course of 30 years. With the caveat, I believe this is consistent with the commission's rules that if Evergreen plugs and abandons one or more wells, that it would get credit for that year for the costs of plugging that well. I believe that is Evergreen's proposal to the commission this morning. I'm getting a signal that I got it right.
Do you mind providing some additional perspective around the 9.6 or the 2.1 and how that was calculated by your client?
We looked at what the total financial assurance would be if you increased the reclamation costs from 31,000 to 58,000. That gets you to 9.6 million. So the total financial assurance would be 9.6 million. 7.558 million of that would continue to be a surety bond, and then the delta 2.1 million would be a sinking fund or a trust fund. Like I said, we came up with this last night, so we don't have the details of that. We haven't worked out the tax implications of those options as well.
Okay, another follow-up question. Appreciate the idea of the 58 for the site versus 31. Does your client have some information relative to how they now are at 58?
We do, and if you'd like a witness to explain that, we have a witness 5 feet from me who could do that for you.
I think that would be helpful. I'm just trying to anticipate my and other commissioner questions as we try to create a record here of trying to determine the appropriate financial assurance.
Sure. With that, I'd call Ms. Mackenzie Smith back to the virtual stand, I guess.
Let's bring Ms. Smith back to the panel, bring her in from the attendee list to the Zoom panel list.
Ms. Smith, did you hear the question?
I did not.
Chair Robbins, would you mind repeating that question for Ms. Smith?
Yeah, so Ms. Smith, your attorney, Mr. Martin, has indicated a proposal this morning that Evergreen would be agreeable to that changes the proposed demonstrated cost for reclamation from 31,000 to 58,000 per site. And my question was, could you amplify how it is that the company has gotten to that revised number? And I would remind you that you remain under oath as you were yesterday, so appreciate that point.
Yes. Jim, did you want to?
Well, after you're done.
Okay. As you all saw in Exhibit A, we included an AFE that was for $31,000, and that was for the external or third-party costs associated with a final reclamation for an average well site. And so this increase to $58,000 accounts for all internal costs now. So not only does it include the materials that we need to purchase, consulting, environmental consulting hours and time, and fuel, which are the third-party costs. It now also includes the cost of labor to do the work, as well as the wear and tear on our equipment, including slip tanks and transportation of the work truck and the equipment to the location, and the time and hours spent for employees to do the hydro seeding, do the hydro mulching, and operate the equipment during the completion of a final reclamation.
Okay, thank you very much. Go ahead.
All in the equivalent cost.
So, yeah, anyone can do it at that cost.
Correct, yes, it is third-party equivalent cost.
Anyone can do it for that.
Okay, and I assume that's Mr. Sexton.
It is.
Yes,
Would you
would
please
you
elevate
admit
him?
me?
That would help.
Chair Robbins, I believe Mr. Sexton would like to address this as well. It's,
Okay,
that's acceptable.
let's,
Ms. Amaro can elevate him.
Thank you.
we're doing that.
Thank you.
Okay, Mr. Sexton, remind you, you remain under oath as well. You're a witness in this proceeding. Did you want to add anything to Ms. Smith's testimony?
Yeah, just, she provided a lot of detail. Thank you, Mackenzie. We heard the concerns of the commission, and the 58,000 simply represents what we could easily go out and get. If our group, Maya Construction still is a separate company, we owned it, we bought it. They're a road and land reclamation company. They move a lot of earth, and that's their best estimate, our best estimate of what a third party could come in and do it for. Even though we could do it a lot less, we heard you say, yeah, but what could a third party do? We don't think, we think since that equipment isn't going anywhere, that it remains available to this company and the state and the commission to do the work. But if it wasn't, that's what someone else could do it for, just pure and simple.
And one final clarifying question for me, and then I'm going to allow my fellow commissioners to ask a question. Mr. Martin, I believe you indicated that the 2.1, which is over and above the 7.558, that would be paid into some form of trust fund or sinking fund, to be paid in over the course of 30 years. Did I hear you correctly? And if my math is correct, is that 70,000 a year?
Yes.
You're correct, Chair Robbins.
Okay. All right. So we've got the renewed testimony this morning. I saw Commissioner Messner's hand raised just a bit ago, and then would look to any other commissioners for questions.
Thank you, Mr. Chair. I certainly appreciate the additional information that was provided by the applicant. At the same time, I think it's important that we deliberate on the application that was presented, and I think certainly at the end of deliberation, there may be opportunities for this operator to reconsider their application and resubmit it. But to make a determination on the fly, again, without the necessary documentation to or clarity, and I'm sure that there would be able to be provided information, but I think this proposal needs to be considered at the end of deliberations, once all the commissioners have been heard on the application on its merits. And then perhaps after that, there may be a consideration or an opportunity for a modified application to come from this operator. But it's hard for me to react on the fly to something prior to deliberating on what's been provided to us.
Does any commissioner have questions of the applicant? Commissioner McGowan?
Thank you, Mr. Chair. And sorry, just for clarification, the 58,000, is that for plugging, abandoning, and reclamation, or is that just the increase to reclamation? Sorry,
That is just the increased cost to reclamation.
okay. So then the total we have for the assumption to P&A and reclaim is 58 plus
10,000.
Thank
Or
you.
I guess given whatever COGCC's P&A structure is, depending on the total depth of the well.
Okay. Thanks.
Okay, clarification, further questions? Commissioner Cross?
Thank you, Mr. Chair. And so I wanted to touch, in the director's recommendation, it did talk about there was reclamation on a location that was 58,448. Is that where you got the information that this is where you could get it done anywhere else, or I'm just trying to compare those numbers if that.
Yeah, no, absolutely. So initially, again, this goes back to, I believe, some of the confusion originally caused by the first application and the second application. Initially, we submitted the AFE that showed the full cost of internal, external, and the breakdown, and where those numbers were coming from. So we reverted back to that original AFE, right, where you saw the 58,000. And so yes, it's not necessarily coming from that. That was always the final number, or the total internal and external number. But in order to avoid confusion, which it only seemed to do that, we had removed the internal costs from it, which got us down to 31. So when staff references a 58 number, it was actually the number we had originally proposed that they were pulling from. Or not proposed, sorry, the number we had originally had on our attachment A.
Okay, that is helpful. And then if I can, just to try and go back to some clarifying from yesterday, I know Mr. Sexton commented on eventually wanting to recomplete all of the low producing wells. But could you remind me what the number of wells it would be? I think you had a number that was going to be within the first 6 years. How many would be recompleted? Can you tell me again what that is?
We had simply made the statement that we would commit to recomplete 150 wells by the end of 2029. I actually hope to do more than that, but we have done 153 or 154 to date. So that's really where the number came from.
Okay. Thank you.
Further clarification, further questions? All right, seeing no further questions, we have now provided staff with the opportunity for comment, and there was none. We've provided the applicant with kind of a final opportunity to clarify its position. At this point, I believe we will move into deliberation amongst the 5 commissioners. So
Thank
if
you,
you want to,
Commissioner.
go ahead, Mr. Martin, did you have anything final?
No, I was just thanking you and the commissioners for your time on this matter.
Great, thank you. Ms. Amaro, we can unelevate the panel members and just have my commissioners so that I can see them better. That is helpful. All right. Deliberations. Who would like to start? Commissioner Messner.
Thank you, Mr. Chair. Just a second here. So I mean, I appreciate the applicant is, proposing some modifications. I think that's warranted, and certainly am willing to consider modifications. I initially, like I indicated, struggle with it on the fly right before deliberating. But I do want to take some time so that folks understand the evaluation that I've done on this. I'm going to apologize because it's going to be relatively long-winded. But I think it's important to fully share my deliberative process on the proposal. And this was really a difficult evaluation for me. It's clear to me that the operator is in good financial health, that has been operating in this state for a long time, and is an important economic driver in the region of the state in which they operate. I do appreciate the application and the work that has been put into submitting it. As I indicated, I'm also appreciative of consideration of modifications to the application. But I want to start my deliberation today with an overview of how I'm evaluating the financial assurance application and what rules and guidance I am using in this evaluation. So first, it's my belief that we have a clear obligation in both the rules and in statute to require every operator to provide assurance that it is financially capable of fulfilling every obligation imposed by the Act. We do this by applying appropriate financial assurance rules and guidance that we developed over the last couple of years. These rules provide, in my opinion, a clear structure for how this commission ensures that it is accomplishing the obligations set forth in statute and in its application of these rules. I believe it is critical that this commission honor the months of stakeholder work, deliberation, and rulemaking that ultimately led to the creation of these rules. The particular areas that I'm focusing on my evaluation of this application are the following: the rules around option 2 plans and operators, the rules and guidance around option 5 plans, the definitions of low producing wells and single well financial assurance, the rules and information requirements around demonstrated costs, the rules around guaranteed performance, and ultimately how the plan ensures that the operator is able to provide assurance that they are financially capable of fulfilling every obligation imposed by the Act. In this instance, the operator is submitting a proposal for an option 5 financial assurance plan. In order to evaluate an option 5 plan, we must first look at what default option the operator qualifies for based on its average daily production. This operator qualifies as an option 2 operator as it has an average daily production that exceeds 22 MCFE and is below 90 MCFE. As stated in the statement of basis and purpose on page 61, Rule 702D2 establishes the requirements for option 2 financial assurance plans. Option 2 operators have a lower daily per well production than option 1 operators. However, option 2 operators are still relatively low risk and therefore may submit blanket bonds based on the number of wells the operator operates, though at a higher amount than option 1 operators, end quote. In this instance, the blanket bond amount for this operator would be $10,000 per well, as it has more than 1,500 wells, but less than 4,000 wells. Option 2 operators are also required to submit single well financial assurance for its low producing wells in exceedance of 5% of its total number of wells, which by rule are any well that has an average daily production rate of 10 MCFE or less. As per rule, this single well financial assurance can be determined by either utilizing the default amounts developed within the rules or by providing evidence of demonstrated costs. I am evaluating the requirements for option 2 as in order for an operator to qualify for an option 5 plan, it must show, according to Rule 702C5, that it is unable to meet the requirements of Rules 702D1 through 4, or has an exceptional or unreasonable or unnecessary circumstances. In these instances, an operator may file an option 5 plan. It is important to note on page 59 of the Statement of Basis and Purpose that in creating option 5, the Commission stressed that it was not intended to be a process whereby an operator may attempt to use option 5 for the sole reason of paying less financial assurance than provided for in other options. In providing an option 5 financial assurance plan as per Rule 702D5, the information requirements for the plan are the same as all other options with some exceptions. Per Statement of Basis and Purpose, page 63, unlike the other options, option 5 allows operators to submit a unique financial assurance plan, though that plan must address all wells, including low producing wells, out of service wells, transferred wells, and other facilities, as is required with financial assurance plans under other options. The Commission intends that the operator will meet the single well financial assurance obligations of its low producing wells based on the production threshold and allowances of the standard option structure. The Commission also intends for an operator seeking an option 5 plan to provide support and justification for such request, end quote. A couple of things to highlight in this excerpt from the Statement of Basis and Purpose. 1, submittal requirements are generally the same as all the other options. This includes asset retirement planning. And 2, that the Commission intends that the operator will meet the single well financial assurance obligations of its low producing wells based on the production threshold and all allowances of the standard option structure. This operator's standard option structure is option 2. This clearly indicates that we shall follow the rule-defined definition of low producing well, which is a daily production average of 10 MCFE or less, and require single well financial assurance for those low producing wells, but still allow 5% of the total number of wells, including low producing, to be covered by a blanket bond. This also indicates that it is not appropriate for this Commission, in my opinion, to allow a modification of the definition of low producing wells in an option 5 plan. It is also important to note that per page 16 of the Statement of Basis and Purpose, much of the Commission's focus in the financial assurance rulemaking was on identifying wells that pose financial risk to the Commission and the public, because it is more likely that an operator will orphan the well. The Commission recognizes that inactive wells, wells that are no longer producing, pose the greatest risks in many cases. but the commission also recognizes that there are wells that pose some lesser risk because their production has declined to lower levels, but they will continue some level of production for some time. Because the commission is adopting rules that treat wells differently depending on their risk profile and anticipated time to retirement, the commission determined that it was necessary to adopt a new definition of low producing well to identify those wells with a lower risk profile than inactive wells, but still some higher risk profiles than a well producing at a higher level, end quote. Now, having said all of this, it is appropriate and anticipated that an operator can provide evidence of demonstrated costs to prove an amount of single well financial assurance that is different than the default amounts provided in rule. The submittal requirements for demonstrated costs are clearly laid out in the statement of basis and purpose and are stringent requirements by intent to ensure that this commission can clearly determine that the information provided is factual and again ensures that the operator is able to meet all of its financial obligations associated with the act. As indicated on page 20 of the statement of basis and purpose, where operators use demonstrated costs of plugging, abandonment, and reclamation, the commission intends for operators to include all relevant costs and information in their single well financial assurance proposal, including, but not limited to, known remediation issues, areas of initial and total disturbance for the oil and gas location and any associated offsite facilities, number of wells at the oil and gas location, whether the oil and gas location has cut and fill slopes, and if so, the slope ratio of both the cut slope and the fill slope, whether the oil and gas location has sandy soils, whether any salt kills have occurred at the oil and gas location, whether the oil and gas location is in high priority habitat, and whether the topsoil has been salvaged at the oil and gas location. The commission also expects operators will support their demonstrated costs with, for example, 3 years of invoices from past plugging, abandonment, and reclamation operations where possible, or a third-party estimate of plugging, abandonment, and reclamation costs. Based on a review of the evidence in the administrative record, the commission determined that these factors are most likely to drive remediation and reclamations costs. The commission recognizes that reclamation costs are primarily determined at a location level and not a well level. And by taking these factors into account, the commission will be able to more appropriately tailor the amount of financial assurance required for each well, end quote. A few things to note in this narrative from the statement of basis and purpose. One, during deliberations during the financial assurance rulemaking, there was significant discussion that the details regarding submittal requirements associated with demonstrated costs should be included in the statement of basis and purpose, as the statement of basis and purpose is able to provide more narrative direction and guidance as to the specificity of the submittal requirements and would be a better place to provide this information rather than the rules. It was done this way upon suggestion from operators to ensure that the submittal requirements were clear. And thus I reject the argument that tries to indicate that the statement of basis and purpose should be ignored as it is not the rules. The language in the statement of basis and purpose and the commission's direction on this topic is clear and precise. The information that needs to be provided is both reasonable and necessary to determine all of the factors that the commission needs to consider in determining demonstrated costs. And the submittal requirements are such that evidence needs to be provided that provides the commission with factual costs for plugging, abandonment, reclamation, and remediation. These costs shall necessarily include all relevant costs and information, including labor and equipment necessary to accomplish plugging, abandonment, reclamation, and known remediation. As I indicated above, these submittal requirements are significant, yet the potential reduction in single well financial assurance amounts are also significant, which leads this commissioner to believe that it is reasonable to expect that this information be provided in detail to ensure that the protection of the state and to ensure that the plan as submitted meets the obligations of the act. Now, to get to the specifics of this option 5 financial assurance proposal, it's not clear to me that this operator has made a compelling argument that as per Rule 702C5, that it is unable to meet the requirements of Rules 702D1 through 4, or has other exceptional, unreasonable, or unnecessary circumstances. As I had indicated previously, this is an option 2 operator based on daily average production. As an option 2 operator, which is indicated in the rules and the statement of basis and purpose, is an operator of good financial health, and while may have more risk associated than an option 1 operator, is still able to qualify for blanket bonding under our rules. The blanket bonding amount for an option 2 operator with this number of wells is $10,000 per well. This amount is significantly below both the rule-defined default single well financial assurance amount of $100,000 per location and $30,000 per well, as well as approximately 30% of what the operator's proposed demonstrated costs for a single well financial assurance amount is at $31,000. Understanding now that it's indicated at $58,000. This operator qualifies for this blanket bond amount because based on our rules, it is of good financial health due to the higher production level of its wells. This operator also has a significant number of wells that are defined per our rules as low producing, even after the 5% exemption. This to me is where the crux of the conversation lies. I do not believe our rules, even in the instance of an option 5 proposal to modify the definition, do not believe our rules allow, even in the instance of an option 5 proposal, to modify the definition of low producing wells. The time to have made the argument for modification of the definition and its applicability to option 5 was during the financial assurance rulemaking. However, the decision was made during the rulemaking to require that the definition not be modified. And so therefore the application of our rules should not be modified. But the rules also contemplated that different basins in the state may have different plugging, abandonment, and reclamation costs. And these costs can be demonstrated to the commission by providing the information I had previously indicated. If evidence is successfully submitted, these can significantly reduce the single well financial assurance amounts associated with low producing wells. However, I do not believe that this operator has provided the necessary and reasonable information and evidence laid forth in the rules and the statement of basis and purpose to justify their demonstrated costs. I do believe it is possible for this operator to be able to provide this information to justify a demonstrated cost, but at this time, it has not. I do believe that this operator has provided information showing its financial health and its intent to continue to recomplete wells at a significant rate over the next 6 years that would significantly increase production associated with their low producing wells. They have also indicated that we continue to do these recompletion operations throughout the lifetime of the field. It can be assumed that when these operations are undertaken, that these wells would increase their production levels above the low producing well threshold and be eligible for the $10,000 per well blanket bond amount associated with an option 2 operator. This would, by rule, decrease the amount of single well financial assurance required by 150 wells over 6 years as proposed by the operator. If recompletion rates occur at the rate as indicated, that it can be anticipated that a significant number of their low producing wells would shift to a blanket bond amount of $10,000 per well over the next 6 years. It is possible that this operator could have proposed an option 5 scenario that would have exempted these low producing wells from single well financial assurance in the same way that a out of service plugging list would with other options, with the commitment to recomplete these wells over the next 6 years and bring them above the low producing threshold and allow them to be covered by the $10,000 blanket bond. But at this time, that has not been proposed. Instead, what is being proposed is an option 5 plan that both decreases the overall amount of the rule-defined blanket bond amount for the option 2 operator, modifies the definition of a low producing wells, and suggests an unsubstantiated demonstrated cost amount. From my perspective, this plan appears to propose what clearly is disallowed within the intent of option 5 plans, which, as indicated on page 59 of the statement of basis and purpose, that in creating option 5, the commission stresses that it is not intended to be a process whereby an operator may attempt to use option 5 for the sole reason of paying less financial assurance than is provided for in other options. It is my opinion that this commission cannot arbitrarily determine that a financial assurance amount be adjusted without the necessary and reasonable information provided by the operator to justify their adjustment to the blanket bonding amounts. They're, in my opinion, inappropriately modified adjustment of low producing wells and their demonstrated costs. I do believe that it is possible that this operator could propose a plan that utilized option 2 defined blanket bonding, evidence-based demonstrated costs, and could have incorporated their recompletion program into a creative out of service type exemption for low producing wells that would have been in line with the intent of the rules. But again, at this time, they have not proposed this. So at this time, I would not be supportive of this option 5 proposal and would classify this operator to an option 2 plan. I would, however, like to provide an opportunity for the operator to provide the necessary information and evidence to prove their demonstrated costs associated with an option 2 plan. I want to emphasize in this opinion that I am applying the rules and the statement of basis and purpose as I believe they are to be interpreted based on our financial assurance rulemaking. Option 2 operators, as determined by in the rulemaking, are operators with sound financial health and realize the benefit of blanket bonding far below the actual costs of plugging, abandonment, reclamation, and remediation amounts. It is my obligation as a commissioner to follow the rules and statute in my application of the financial assurance rules that have been promulgated as directed by statute. And I feel like I have done that in this opinion. So with that, Mr. Chair, those are my deliberative thoughts.
Commissioner Messner, could I ask you to amplify that last piece of not supportive of class 5, classify it as an option 2, quote, like to provide opportunity to show demonstrated costs? How do you anticipate something like that happening in your singular opinion?
Well, I do think that we have the option as a commission to make a determination on what's being proposed here, but to have the discretion to allow for this operator to resubmit a plan that takes into consideration some of the comments that perhaps are provided by the commission during an option 5 hearing, to be re-reviewed at a hearing at a future date. I think the other option that we have, because I don't think we can arbitrarily modify this ourselves. I think our decision points are either to deny their option 5 plan, which would put them therefore into a default option 2, or to allow them to resubmit a plan that then we could deliberate on and react to. But I don't think we can create an option 5 plan for them.
Okay, I disagree. I think we can't create an option 5 plan for them. I'm not sure I'm in that spot where we would do that today, but I think that the option 5 was indeed the recognition by the commission that while we try to do our very best in creating financial assurances, in creating the 4 options, it's really hard. And trying to define options that would fit every particular operator was a nigh impossible task. And so I think that's why we did create option 5. I do find that this operator should be option 5. I don't think that they fit necessarily well into option 2. I think they get unfairly hammered by the fact that their operation profile has a bunch of wells that are less than the low producing number that we created. And I think that's where the intelligence of the commission, informed by the information that the operator brings to it under option 5, allows us to be creative to address an option 5 approach that is particular to an operator and that also meets the rules that you've articulated, that every operator needs to ensure that they can be financially able to address all their concerns. That doesn't really help me trying to figure out, like, where do we go from here? But those are some of my initial deliberative thoughts based upon some of the good points that you've made, Commissioner Messner. Other commissioners that would desire to deliberate? Commissioner Cross.
Thank you, Mr. Chair. And I'll start off kind of building on what you just discussed. I too think that this operator is a good candidate for an option 5 plan. As Commissioner Messner said, the plan 5 was designed to satisfy financial assurance obligations that, quote, make it unnecessary or unreasonable for the operator to submit the financial assurance amounts specified, and looking back at options 1 through 4. As Commissioner Messner said, and as I think the testimony showed, I think they're in a good financial position. And so when it comes to unable, I don't think that that's a sense. I think we have to start to look at, is it necessary to submit those amounts? And I think this is kind of where I differ from Commissioner Messner, and I bring back my thoughts that were expressed during the own resources financial assurance as well. And I want to specify that by bringing up own resources, I do not mean that I want to create any kind of precedent or this is the way it should be done, because I truly think that, especially in an option 5, it is a very case-by-case individualistic plan. But I think in terms of certain operators around the state, such as those on the Eastern Plains, such as those that are operating in coal bed methane wells where the production amounts are less, but still profitable, I think that's a kind of situation where it becomes unnecessary or unreasonable to submit the amounts, whether it be the low producing amounts or what the case may be, that are specified in those option plans. And I think that that's why an option 5 plan is good, to say, while a low producing under the statutory rules makes it a high risk well for other operators, under the system and under the business case in which we operate, these are profitable wells for us. These are not wells that we're in danger of shutting down, plugging and abandoning and reclaiming, or having to orphan right now, because at 5 MCF, yeah, it's low producing for others, but at 5 MCF, that's the money for us. And so I think it's important to recognize that while the assumed low producing is important for the vast majority of operators in the state, I think it's important to note that there are those exceptions that can make it unnecessary or unreasonable to focus purely on those. And so I do think that option 5 is a good plan to be devised for this operator. That said, I think that there are problems with this application as it came before us. I want to first talk about demonstrated costs, and I don't want to belabor too much on demonstrated costs because I agree with much of what Commissioner Messner said. And I want to first state that I understand and agree with Commissioner Messner that the statement of basis and purpose really is something that the detail was put in there because it's not reasonable for the detail to be put in the rules. Where I do want to disagree with Commissioner Messner slightly is that the statement of basis and purpose is not binding. That said, I think it is strong guidance that needs to be looked at, and it's strong guidance that illustrates to applicants what the commission expects to see. And I think part of the reason this difference in thought is important is because as we continue to move down the road, I was not a commissioner that was involved in the deliberative processes of the rulemaking for financial assurance. And as we get further down the road, that will become more separated. And so I think it's important to recognize that we have to look at what's in writing and what's mandatory. So the things that are absolutely mandatory are the things that are in statute, the things that are in rule. We look to the statement of basis and purpose then as the guidance for it. And as I said, I completely agree with Commissioner Messner. It's not reasonable to say, here's every single thing that we want to see in demonstrated costs within the rule. I think that there will be situations where all of that information cannot be provided. Sometimes additional information may be provided that's not in what's provided. And that's why I think it's important to look at it as guidance of what is expected to see. And it's important to highlight that this is an illustrative list, not an exclusive list. Going from there, I don't think that as presented, there was enough information to truly provide demonstrated costs here. I appreciate the operator coming today and saying, we want to go back to the AFE that we initially talked about using at 58,000. I think that could be more reasonable. I just don't have that information at this point in time because, as Commissioner Messner said, we can't really work off the fly and try and get this information. I think that demonstrated costs absolutely could show that it's far less for $100,000 in reclamation. We had public commenters talking about what if we want to keep roads. I know that for many of the ranchers in this area, they will plan to keep roads. So that's going to lower the reclamation costs if that's approved. I know that there's smaller footprints compared to some of the operations we see in other areas. That's going to cost less. And so I can fully understand that the demonstrated cost for reclamation will be far less than $100,000. I just don't think we've seen thus far enough evidence to show that these are what the demonstrated costs are. And then the other thing I want to talk about is the asset retirement planning. And for me, this is where I really got caught up in what was provided. And where I got caught up is essentially what the operator has proposed to us is we're going to keep doing this forever. We're just going to keep recompleting wells until there's nothing left. But they haven't even really said how they're going to retire the assets, even once we get to that point. Even if we look at it in the most basic form of what was provided, the operator has told us that over the next 6 years, they will recomplete at least 150 wells. The problem that I see with that is under the plan proposed by the operator, using 2 MCF as low producing instead of the 10, we are starting to see there's still 354 wells that are going to be considered low producing using the 2 MCF level. So even if over the next 6 years they recomplete 150 wells, we're still left with more than 200 wells that are going to be low producing. And I anticipate that number will continue to grow as the field ebbs and flows, with some wells starting to drop before that, below that 2 MCF level. And so while I fully appreciate and understand that recompleting these wells will continue to make these wells profitable, I still need to see some of that information that, as Commissioner Messner said, is required in all of these options, including the asset retirement planning. And the fact that at this point in time, what we're being told is we're not really going to have to plug and abandon or reclaim these wells ever. So we're kind of setting this money aside because we have to set this money aside. I need to see that there's some kind of asset retirement planning done, that at some point in time, recompletion, which they even suggested is only 96% effective. At some point in time, these wells will have to be plugged and abandoned and reclaimed. At some point in time, recompleting the wells can only be done so many times. It's going to be, that decline curve is going to continue to go down. At some point in time, we will have to meet the obligations that we have as operators under our rules and under our statute to plug and abandon and reclaim those wells. And so regardless of the option that's looked at, I think you have to make sure that you're showing this is how we will meet our obligations. And at this point in time, I don't see any way that they're trying to show that they will meet those obligations by, at some point in time, retiring. When we, again, looking back at own resources, they said, we have done some recompletions. As it's gone down, once it hits a certain level, that's when we're going to start to plug and abandon. So they gave us that retirement planning that says, this is when we will move from what everyone else considers low producing, but we consider profitable, to now we're going to move this into our plugging and abandonment list. They gave us that information. And I think that kind of information is what makes me comfortable with something like an option 5 plan that I fully agree is something that should not be tried to be proposed by all operators. I think most operators in the state will fit into one of their options, and the option 5 is really for kind of these unicorns that don't meet the other options in a normal situation. And so, at least for me at this point in time, I agree with Commissioner Messner. I would like to see a resubmitted plan, because I do think that they could submit a plan that would be approvable under, at least under my view. But at this point in time, particularly because of the lack of demonstrated costs and because of the lack of asset retirement planning, I cannot approve this plan.
So Commissioner Cross, I'm trying to amplify each commissioner's points. You would not approve anything that's being submitted today, and you would direct the applicant to resubmit an option 5 that does a better job of demonstrated costs based upon the rule and the SBP and the things that they are seeking to prove up. And their resubmittal would also need to necessarily have an asset retirement program that they are proposing, which is yet another thing that option 5 requires them to do, which in your opinion, they've not done. I'm just trying to capture each commissioner's perspective so that if we get to a point that we're trying to figure out next steps, we can understand where everybody's coming from.
Yeah, I think that absolutely characterizes my view. One thing that I will just briefly mention, I know that you said we could probably kind of create our own plan, and Commissioner disagreed. I am on Commissioner Messner's side with that. I don't think that we can just create our own plan here. I think we can ask them to slightly modify maybe something that they submitted, but ultimately I don't think we can come in and say, all right, let's give them this instead. I think it needs to come from a plan that they create.
And I'm not necessarily saying that that's the right approach or not. I would note that 702E2C does allow the commission to approve a financial assurance plan, quote, subject to reasonable and necessary conditions of approval. So I think there is the flexibility there for us to be creative. And that was the point I was making. I'm not necessarily thinking I'm all that creative this morning, but I think that the option does exist.
And I agree that we can provide conditions as we did with some of the increased reviews for own resources.
Right.
I just think that at this point in time, trying to create, okay, let's come up with an asset retirement plan for them and anything like that. I don't think that that's something that we're capable of doing in this situation.
I'm seeing Commissioner McGowan very animated over there in the left-hand corner, shaking her head up and down.
No,
I'd like to
I'm just-
recognize her next.
Thank you, Mr. Chair. I agree with everything my fellow commissioners have said. I do think that this is an appropriate use of the option 5. We did talk about there are instances where operators are in good financial health with a field or a portfolio of low producing wells, that those two things are not necessarily mutually exclusive. And so I do think this is an appropriate path for them to have asked for. I'm also in agreement with Commissioner Cross and I'm also appreciative that they heard us yesterday and they tried to address the demonstrated costs and reclamation costs and try to put out in front of us some sort of an asset retirement plan. But I don't know how to back those numbers up into anything. I don't know how they arrived at those. I don't know why $2.2 million would be an appropriate amount over 30 years. And so I think there's still more discussion to be had with this commission. If we do decide to come back and revisit and ask the operator to try again, I do not feel I need to hear any more of the financial health of this operator. I think that for me, there's clarity there. I think it's these kind of outstanding issues for me that I need to see before I would be comfortable signing off on the option 5 path. Otherwise, I think I would be in agreement with Commissioner Messner that trying to figure out how to use an option 2 for this operator might be appropriate if they can't figure out how to give us what we need for an option 5.
Thank you, Commissioner McGowan. Short, sweet, elegant, and to the point. Commissioner Ackerman?
Thank you, Mr. Chair. This is such an important discussion. I'm glad we're having it. And I wanted to first say thank you to the operator and thank you for your patience as we have this discussion. You know, we're all in this together trying to figure out the best way to protect the state of Colorado and to appropriately, extract natural resources while doing so. It's a big topic. It's a big issue. And I recognize the difficulty facing the operator as they attempt to propose an option 5 plan. As I think Mr. Martin pointed out towards the beginning of their presentation, purposefully, there's not a prescriptive recipe to do so. And I think that was by design, as Commissioner Cross pointed out. I also wanted to say I appreciate Evergreen's efforts in preparing for the hearing, their staff expertise and their council's professional management of the application process. And I agree with Commissioner McGowan that I appreciate their willingness to pivot and continue to evolve this financial assurance proposal. Also, in my appreciation comments here, I appreciate Commissioner Messner's thorough review of the regulations from which we're working and support the points that he made associated with those regulations. And so I'll try not to repeat those pertinent points that were already made by him. I'll simply state that I think we're on the pathway to figuring out the appropriate financial assurance plan for Evergreen as we work together. But I would agree that I don't think this application gets us there in its current format, even with the game time modification and further discussion this morning. You know, in its application, Evergreen has demonstrated many positive attributes, and I commend them for their persistently innovative approach. Chief among those attributes, of course, is their strong financial viability, a good compliance history, and their innovative intent to continue to recomplete wells into long-term production. With regard to financial viability, I think the operator spent a significant portion of the hearing on this point. And I think, as Commissioner McGowan stated, Evergreen adequately laid out their financial viability and potential for ongoing financial viability. That said, financial viability is a component of the necessary analysis, but really only one component, and arguably a less important component when it comes to proposing a financial assurance plan that is chiefly based on demonstrated costs. So again, as Commissioner McGowan pointed out yesterday, the whole purpose of financial assurance is to ensure the state isn't left holding the bag, as I think it could not be argued that hasn't been the case way too often in the past. I also think that I agree with the director's recommendation that Evergreen's compliance history is adequate for such a proposal. And I wanted to spend just a little time talking about the impact of the recompletion program business plan. I think Mr. Sexton's point is well made on this issue, and I think the fact that Evergreen's business plan of recompleting low producing wells should have some impact on the amount of single well financial assurance provided, depending on the number of well candidates for the recompletion plan. But recompletion plan notwithstanding, I'm not swayed that these wells won't ultimately need to be plugged and reclaimed. The recompletion plan simply shifts the date of potential P&A and R activities rather than preventing those actions altogether in perpetuity. And in my opinion, failure to provide full single well financial assurance for any associated low producing wells would not adequately provide for the ultimate retirement of those assets. And while Evergreen has demonstrated these 3 points well, in my opinion, it's fallen significantly short of providing the information necessary for me to comfortably make an option 5 financial assurance decision based on demonstrated costs, even with the revised submission of reclamation costs and bonding provided this morning. You know, demonstrated costs, asking for a financial assurance plan based on demonstrated costs, to me, simply necessitates the ability to clearly and completely demonstrate actual costs for plugging and abandoning and reclaiming wells. So put simply, that should simply be, we or another relevant third party have taken these applicable P&A and R actions, and it actually cost this much. The more robust that information is, the more comfortable I am with the coming to an appropriate single well financial assurance figure. The only complete estimates I saw in the application as part of the proceedings were estimates for an undisclosed location around $31,000, and then a previously submitted document, as was pointed out by Ms. Smith, for another undisclosed location around $58,000. And there was significant discussion about varying degrees of counting or not counting an operator's out-of-pocket costs. I want to reiterate my statement that I don't agree with the practice of excluding costs for the purposes of financial assurance discussions that could currently be borne by existing company staff. In my opinion, it's clear costs should be demonstrated as if they would be provided by a third party, as the likely result of the activation and ultimate use of financial assurance would be to perform P&A and R and remediation activities without the benefit of those in-house services. There were a lot of points that were laid out in this application that I don't feel were addressed really at all by the applicant. Some of those were pointed out yesterday in the director's recommendation, known remediation issues was focused upon. There are 21 open projects, and remediation is intended to be part of a financial assurance plan. This issue really wasn't addressed, and the director estimated approximately, well, a minimum amount of about $500,000 simply to address open remediation projects. I honestly would expect that number to be larger, as Mr. McDonald testified in his initial comment and has been discussed during the hearing. The company has been very active with heavy earth moving equipment. And as we discussed yesterday, heavy earth moving is a significant expense and will require significant earth movement for reclamation, which will carry a large cost. I think addressing remediation and certainly talking about cut and fill slopes and earth moving is very important. Other points that weren't really significantly addressed in the application was the amount of area of disturbance, the number of wells per location, decompaction of soil, as was pointed out, cut and fill and slope recontouring, soil type, salt kill, soil amendments, revegetation, stormwater erosion control, high priority habitat, all had no supporting information provided, and how those play into potential reclamation and remediation costs. So based on the evidence submitted, my understanding is that the operator's estimate was that $3,332 per well was the appropriate amount of P&A&R for Evergreen's wells. I don't agree with that figure. I think that all of these factors need to be demonstrated and formulated to a complete and clear estimate of full reclamation and remediation and plugging and abandoning of this operator's assets. And in my opinion, it needs to be done with the idea that what will it cost should this operator go defunct tomorrow? Although I don't intend at all to imply that I think that will be the case. I do think that that's the intent of financial assurance. So for me, the take-home message, honestly, to Evergreen is that I do feel we have a skeletal argument here that may ultimately provide enough information to begin a discussion for an option 5 financial assurance plan based on demonstrated costs. Should it be able to address the points that I and other commissioners have raised in this hearing. I think what is glaringly missing is an actual full production or even full estimate of realistic demonstrated third-party P&A&R and remediation costs. I do think this operator's unique business model of significant recompletion program, in my opinion, could justify a conversation regarding the reduction of single well financial assurance dollars actually needed for Evergreen's regulatorily defined low producing wells, but agree with Commissioner Messner that a foray into the redefinition of low producing wells on a case-by-case basis is something that this commission shouldn't embark upon lightly. And I think the reason for the justification of potential single well financial assurance reduction for regulatorily defined low producing wells is justified, as it's possible that, as testified by Mr. Sexton and others, that roughly half at least of those wells could become higher producing wells that would be covered under a blanket amount. That said, I would also be open to a discussion of the concept that Evergreen provide full financial assurance and that they be able to remove single well financial assurance on an ongoing basis as wells are one by one recompleted and thereby exit the regulatorily defined low producing category. Mr. Sexton stated in the hearings that orphan wells aren't going to be a problem as long as Evergreen's the operator. I think Evergreen's demonstration so far of their operations would substantiate that. I think there's a good chance that if all variables remain relatively constant, that this might be the case for the near or even midterm future for Evergreen. And in addition, I understand that the current healthy financial viability of Evergreen may lower the risk of abandonment. But I would just clarify that history has shown in this state that things can change quickly in this industry, even for a company which has a good history, even for a company which has a good business plan and is currently operating properly. So, and I would say to wit, the wells in question here have been in the hands of 3 separate companies in the past 15 or so years. I think that's a point worth considering. So the bottom line to me is that adequate financial assurance is needed for these wells. The recompletion plan, in my opinion, may have some bearing on the timing and potentially the amount of single well financial assurance that would be needed, and could possibly foster some discussion to this operator on the proper amount of single well financial assurance that should be considered associated with low producing wells. Nonetheless, the purpose of proving up a financial assurance plan based on demonstrated costs is exactly that. Demonstrated costs, rather than the preponderance of the proof being information surrounding a company's present financial health and current business plan. And so as such, I also can't recommend approval of an option 5 demonstrated cost financial assurance plan as currently proposed by the operator. I think a good place to start would be Evergreen working with the ECMC staff to resubmit a plan that staff feels is reasonable and staff finds acceptable, or in the event that Evergreen wants to make an argument that when staff isn't in concurrence with a plan submitted, a plan that is clearly complete pursuant to the guidelines and points, particularly from the regulations set forth by Commissioner Messner in his testimony, but also in accordance with the testimony of the other commissioners during this hearing. That said, Mr. Chair, I certainly am open to further discussion on this topic, whether it be today, but my preference would be, I think there's enough work to be done on this application that there should be a retooling and a resubmittal of the application prior to further deliberation on actual decision-making by the commission.
Great, thank you. Appreciate the comments, Commissioner Ackerman. Appreciate and will reiterate the initial point that you made, that we thank everyone for their patience and the importance of having this discussion, and that we're all sort of in this together. We're all working under our rules to ensure that every operator is able to undertake their financial obligations with regard to retirement. I think what I've heard, and try to sum up where folks seem to be, is no one is in a place, none of the 5 commissioners are in a place to approve an option 5 well today, number one. Number two, I believe we have provided extensive direction to the operator in terms of potentially resubmitting an option 5, addressing the asset retirement, addressing the demonstrated costs, et cetera. I'm not going to try to summarize everything that was heard. The operator can go back to our YouTube page and listen in. I've taken extensive notes, so I'm sure they can do the same thing, and they know the areas that need to be brushed up with potentially a resubmittal. I appreciate the concept of, working with staff in terms of a resubmittal on option 5. I think if that's the direction that, and then a third thing, obviously, if the operator desires, they can agree to the formulaic option 2 approach. So I might bring Mr. Martin back to the table to determine which direction his client may want to go. If they do want to just do the option 2 approach, which I don't think they do want to do, then we're done and we can just approve the option 2. If they want to undertake a resubmittal on an option 5, I think it would be incumbent upon this commission to provide a deadline within which said resubmittal would happen, and the resubmittal would address the concerns as articulated by the 5 commissioners today. I don't know if 30 days or 60 days is an appropriate time frame, but the concern I've got is if we don't have a deadline, then the operator can just kind of lie in limbo with their old financial assurances, and I don't believe that's appropriate for the state of Colorado either. And so would like to, again, Ms. Mario, I'm indicating if you could bring Mr. Martin back to the table, I would appreciate it, to have a quick discussion of whether there is a agreement to just go with the formulaic option 2, or if they want to take us up on the offer of a resubmittal, what is a reasonable and appropriate time frame to get that accomplished? Good morning, Mr. Martin. Good to have you with us again. I assume you've been listening in with to the discussion. I've articulated a couple of potential next steps. Would like to hear from you relative to what the commission has deliberated on and where your client may be.
I guess, first of all, can you hear me, sir?
Yes, we can hear you.
Great. That's one success for the day. I'll try and work seriatim through your questions, Chair Robbins. One, Evergreen continues to believe that an option two plan would be unreasonable and unnecessary. So we'll clearly want to pursue an option 5 plan. We appreciate that opportunity. A couple of thoughts building on, and I'll get to deadline in a second after I make a couple of other comments. One, building on what Commissioner McGowan said, it would be helpful if you told us what parts of a submittal you don't need. We can continue to provide financial information if you want, but it sounds as if perhaps that's not necessary. The option or the application process it involves a lot of paper and a lot of material. So if there are materials you don't need or issues you believe have been covered, that would be helpful, so we don't submit once again a huge amount of paper for the commission and for the staff to review. Building on what Commissioner Ackerman said, it would be helpful if you could encourage the staff to actually engage with an operator in developing a financial assurance plan, in particular in helping us understand what they expect in terms of demonstrated costs. That would certainly be helpful. In terms of a deadline, I understand your concern about floating in limbo, I think you said. On the other hand, we have a lot of work to do to deal with demonstrated cost retirement plan and perhaps other things. We'll review the recording carefully to make sure we cover all of the issues that you believe need further elaboration, but I'm going to suggest 90 days just because it's a lot of work, and this isn't the only thing Evergreen is working on. It's not the only thing I'm working on, and time passes quickly when you're working with a lot of detail like this. Have I hit the questions you answered, Chair Robbins, or have I missed anything?
I think you, for the most part, hit on. I think to answer the question on what's not needed, I think that I heard most of the commissioners feeling fairly comfortable with the information, witness, et cetera, around the financial health, the financial integrity of the company. And so I do not believe we need further information in that regard. I think that focusing, going back and listening to the record, I think each commissioner did a good job of articulating areas in which additional information could and should and needs to be met around demonstrated costs. And in that regard, Mr. Martin, I would point out that the SBP, which I think is good guidance for us, speaks to a kind of location by location assessment of costs. And I realize that's difficult for an operator that's got 2,000 plus locations, but I think there is a grave distinction between the undisclosed location that articulated 31,000 and a second undisclosed location that articulated 58,000 as compared to 2,000 different locations and costs. So I think your client can do a better job of demonstrating costs that are reflective of actual circumstances on the ground. I don't need 2,000 assessments, or at least this is just me talking, but I think we need more than 2 undisclosed location assessments in order to allow your client to qualify for an option 5 demonstrated cost scenario that relieves them from the formulaic numbers from option 2. So I hope that direction is helpful with regard to demonstrated costs. I think your client could also spend time working on an asset retirement plan, and that's specifically called out by option 5. And I think that all 5 commissioners feel that we, sort of missed the mark there. Knowing full well that these, may not retire for 35 years or more, according to the testimony of Mr. Sexton. But I think that, coming up with $70,000 a year for the next 30 years, I don't see much of a basis for that. And I'd like to be able to kind of pinpoint a decision based upon actual numbers that, add up. Again, I'm just trying to provide additional direction to your client. With regard to the time frame, I would suggest that, I would be more comfortable if we suggested 60 days. And then if for real purposes, your client is running up against that deadline and they don't feel like they can meet it, they could ask for an extension based upon specific illustrative things that are happening that require an additional 30 days. Commissioners, I'm just trying to steer us into a specific direction for the applicant here. If anyone wants to weigh in that the chair's getting this wrong, just let me know. And if you want to weigh in on some other things, that would be great too. Commissioner Messner.
Thank you, Mr. Chair. I do think you're doing a good job on hitting the points, and so I really appreciate that. I think I want to emphasize a couple of points that I made, and I understand that others may not agree with me, but these, at least from this commissioner's standpoint, are going to be important. I'll reiterate that I do think an option 5 plan is possible for this operator. I'll reiterate that I don't think a modification of the single well financial assurance definition is appropriate. I do think that demonstrated costs can be developed, and I think the operator needs to question that. I also think that understanding that this operator is an option 2 operator and qualifies for a $10,000 per well blanket bond, that any modification of that $10,000 per well blanket bond needs to be clearly justified. And I don't believe that justification was provided in this application. And to me, that's an incredibly important piece because I think that we made a determination during the financial assurance rulemaking that $10,000 per well blanket bond is appropriate, reasonable, and necessary for an option 2 operator of good financial health, and with the average daily production that would qualify it for an option 2 plan, and it is significantly less than single well financial assurance, no matter how you define it. And so I think that any modification needs to be clearly justified. And I also think the operator has an opportunity to be really creative with their recompletion plan and contemplate potential exemptions from single well financial assurance for certain wells that could be committed to be in some sort of creative recompletion plan. And I think that type of creativity is something that option 5 plans were developed to allow, and also is within the rules because it doesn't modify single well financial assurance definition and potentially doesn't adjust any kind of option 2 blanket bonding amounts. So just a couple of thoughts from my perspective there.
Thank you. Further direction from commission to applicant. Are folks okay with my suggested 60-day turnaround? Okay, seeing nodding of heads in agreement. All right. Well, with that, Mr. Martin, are you and your client adequately apprised of the position that the commission is in, and you may not like the 60-day, but if you get to 59 days and you feel you need more time, justify it to the hearing officer, and I'm sure you'll get an extension.
I appreciate it, Chair Robbins. We'll do our best to get you something in 60 days, but with all due respect, between the 5 of you, you've asked for a fair amount of information. We'll do our best.
I recognize that point. All right. With that, I believe we're at a spot in which we would call upon AAG Davenport to help me get perspective on the appropriate next step. Do we continue this matter for 60 days? Do we take no action with the direction as is set forth? What are your thoughts there, AAG Davenport?
Well, I think you have a couple of options. You could keep this matter open, continue it for 60 days to allow the operator to submit a new plan. You could also move to just deny what's been submitted and give the operator 60 days to resubmit. I don't know if what's easier for the hearing staff to deal with it. I think a continuance would work.
I think I like the idea of a continuance for 60 days. If there's a denial, I think there may become a procedural requirement that we need to have a resubmittal and a new docket number and a new everything. And I don't know that that's necessary. So I guess I would make a motion to continue docket 2211000286 for 60 days. As part of my motion, if the applicant believes that additional time is necessary, they can make a filing for an extension no more than 30 days based upon good cause as is set forth in the filing to the hearing officer, and the hearing officer is given discretion to grant or not said continuance based upon good cause as shown in the filing. I would also include in my motion that the applicant is directed to come back in the application with information, witnesses, exhibits that meet the direction as is articulated by commissioners during deliberations this morning on August 31st. And I would just note for the record that that is going to entail a fair amount, but I think that the applicant is also directed that we don't need to hear information relative to financial health or financial integrity, that they've satisfied that portion of the burden relative to obtaining of an option 5. So that's a long, conjabbered motion, but I think it articulates the points that I need to make. Do we have a second?
Second.
Motion and second. Further deliberation and discussion? Seeing no further deliberation, all those in favor of the motion signify by saying aye. Aye. Any opposed? Motion carries unanimously. Mr. Martin, thank you for the work here. Thank you to your client. I want to thank staff as well for the good work that they've put into this. I would direct staff to engage, as best you can, but it is the burden on the applicant to meet and carry the burden to provide us with the option 5 information necessary to make an educated decision on whether option 5 or option 2 moves forward. We have concluded the business of the agenda for today. Would look for a motion to adjourn.
So moved.
Second.
Motion and a second to adjourn. All those in favor signify by saying aye. Aye.
Aye.
Any opposed? We are adjourned. Thank you.